Thank you, Larry. Well, welcome, gentlemen. Once again, we are here with the two remaining candidates, Gary Maxwell and Pat Jones, for the district attorney for the 20th Judicial District. We're going to be asking some questions. This will be a little bit more informal than the last time we were together. I just ask you to make sure that your answers are complete but brief. I remember the Dothan Fire Chief telling me about the B's of public speaking. Be brief, brother, be brief. So
would you remind him of that?
But Rickey and I we're going to just ask questions that we think are important for for people to get to know which one of you. I mean, it's down to the two of you now, and there are a lot of people out there that didn't vote for either one of you who are looking for a candidate now, and we thought it was only fair to give them the opportunity to hear from you again as they try to make up their mind who they're going to vote for.
Yes, sir.
Okay?
Thank you.
Appreciate it.
And we'll just try to alternate back and forth. I guess, Rickey, if you've got a question, go ahead and start with whichever candidate you want to start with.
We'll start in alphabetical order this time. Pat Jones. What is the most important responsibility of the district attorney?
I think the most important responsibility, the way I see it, is to keep our community safe. I think that there are several aspects of that, but prosecuting crime, defending the rights of victims are all part of that equation. And I think it's what my focus if God allows me to have this position would be to do everything in my power to ensure that this continues to remain a safe haven for families, for raising our children. And I'm a grandfather. I believe Mr. Maxwell is too, and we want it to be, or I know I want it to be, and I sure believe that he probably does too, that we want this to be a safe haven for our children and grandchildren to want to come back to, just as we did.
Mr. Maxwell?
Well, the role of the district attorney is a little bit different than the role of a criminal defense attorney. A criminal defense attorney's job is to get his client off, whereas the district attorney, the job is to make sure that justice is served. And in doing that, we have to realize that not everybody who is charged with a crime is guilty, and that when you go to grand jury, that you weed out those cases where an allegation has been made, but there is no probable cause to show that that person actually committed the crime. So there is a difference there, and I think that is the primary goal of a district attorney in any circuit, is just to make sure that justice is served and that everybody is treated fairly and equally.
Okay, John?
Yes, well, follow-up questions on that. Mr. Maxwell, you mentioned that defense attorneys are there to try to get their client off. They're there to provide a vigorous defense, and it is a contested argument between you and the defense attorney. So I would ask each of you, in looking at your campaign contribution forms, I see that most all the attorneys here in this area gave both of you money. How do you rectify the fact that you got campaign dollars from the same people that you're going to be sitting across the courtroom from?
Well, I think that's very easy for me to answer. As Rick knows, Jim Parkman and I grew up together here in Dothan, Alabama. We were very good friends. We remain very good friends. And we were out to lunch together one day, and a juror came up to us and says, "How in the world can y'all go out and eat lunch together when you're fighting like cats and dogs in the courtroom?" And that's just the thing. You have to put aside personal feelings towards not only the attorney, but a defendant, if you happen to know them, and you have to do your job thoroughly. It is an adversary system, so when we, as I say, tee it up in the courtroom, I go at it as fully and as aggressively as I can, while at the same time trying my best to make sure that justice is served, and that if there's something that comes up that shows that the defendant may not have done this, then it's the job of the district attorney to let the defense attorneys know that. Doesn't work that other way around. They're not going to show us if he's guilty, but yeah, there's not a problem, and I think I have demonstrated that throughout the years, because most of these guys are my friends and have been my friends, but yet when we get in the courtroom, it's no holds barred then.
Mr. Jones?
I would concur with a lot of what Mr. Maxwell just said. That is the truth. When we are trying cases, it's not a personal thing. The evidence, what we're trying to bring out is what the truth is in the bring the truth to the jury and help explain that story to them about maybe a motivation or but it's not a personal. Sometimes people's feelings get hurt that are involved in the situation. But most of the time, with most attorneys, we try to keep it professional. We understand that we each have a role and responsibility to do for the truth to come out and for the jury to make a determination on the facts that are presented before them.
And make the system work. The attorney's job is to make the system work.
I'd like to ask one more question, Ricky, and then I'll let you have it back. I want to talk about this because we're on this subject of defendants. Now, you mentioned in an earlier statement that not all defendants are guilty. Then why is it that our system treats people as though they are? Why is it that people are arrested, they're booked into the jail, they're barely fed, they're charged for every single thing that they do, and they are treated as though they are guilty from the time they're arrested until they go before a jury? I mean, is it just a mindset, or is it what is it or is it just the way I'm looking at it? I mean, I just see sometimes, and we hear a lot, and we're hearing a lot here in Dothan and Houston County right now about how some defendants are treated when they're arrested and put in jail, how people are left in jail for months and years, and they're not allowed visitation, and they're not this, and they're not that. What is that just a perception from the public, or is there a reality there that people are treated sometimes unfairly by the system?
I guess I'll start off if that's okay.
Go ahead.
I believe that, I don't know, with media and things like that, it's kind of like it's human nature that we believe that you're guilty until proven innocent. It's supposed to be the opposite way around, that you're supposed to come in, and I've heard the judges say it frequently, that they're presumed to be cloaked in innocence when they're sitting before the jury right now, before you've heard any evidence. And that's the way it's supposed to be. Now, I understand that there may be specific facts and circumstances in a particular case, if it's a capital murder or something like that, that might cause, maybe... I don't know, something that you were saying that they weren't allowed visitation. I'm not familiar with any case that would be like that, but I know that they would have opportunity to, of course, to visit with their attorneys and things like that. And unless there was some unusual circumstance, I don't know that there was a sickness. I've heard people being on lockdown or quarantine or something along those lines. Sometimes, of course, bond is not appropriate in a capital murder case, and that's just not going to happen in those scenarios. But I honestly believe that most of the people that are charged, not all of them, but most of them probably are guilty. And there's a presumption, I don't know, when the public is hearing about the case, it's just maybe human nature that we just think you're automatically guilty because they've been charged. And with the media and with the advent of the technology, with all the different forms of media like Rickey Stokes News and the Dothan Eagle and the TVY and Larry McKee Show, there's a lot of opportunity to get that out there. And sometimes it's a really good thing when you're trying to catch somebody that's committed a crime. I've seen you be very successful being able to catch people that are committing thefts and robbing businesses. We need to catch those people. But I hope that's answered your question to some degree.
Mr. Maxwell?
I think the fact that so many people these days have cell phones or that can record what's going on instantaneously, and the fact that so many of these stores have camera systems. I know that I think Rickey's done it, that they've had video from a theft from Walmart, and it goes on social media. Well, you know, it's hard for somebody that said, okay, you know, that's John Doe. I know that's John Doe, and we're seeing him on this video committing this crime. Now that they've got that mindset, he is guilty. And regardless of what a judge or a jury or the justice system going up to the point of the trial tries to say to a juror or a witness, they can say, no, I'm not presuming him guilty because I saw that on Facebook or I saw that on Twitter. I saw the clip on WTVY, and I know he's guilty. So that does have a lot to do with it, I think.
A lot of times what they see, there's a lot of facts that go into it. It's not just that little 30-second soundbite. There's 1,800 or so drug cases behind on being indicted. There's cases that have been arrested in 2013 that they do not get indicted until 2015. I understand that the current administration, and none of this is meant to knock the current administration, is not letting people plea on information or apply for pretrial until we get forensics back. If somebody wants to plead guilty and you don't have forensics back, what's your position of going ahead and taking pleas on information to reduce the backlog on some of these cases, or allowing them to go ahead and apply for pretrial and getting a determination?
My opinion, you know, nobody knows better than that defendant what he had in his possession. You know, if he's charged with possession of marijuana or cocaine or methamphetamines, whatever, he knows what he has. And he doesn't really need a lab report to confirm I had marijuana. So in my opinion, if a defendant wants to go ahead and he enter a plea, or he wants to apply for pretrial, maybe, you know, it's the state's obligation to inform them we do not have a lab back. And of course, that's one of the first questions a defense attorney asks, can I see the lab? But once you explain to them we don't have a lab back, if they say, hey, I want to go ahead and plead guilty anyway, I don't see one problem with that at all.
And I feel exactly the same way. I don't know if you remember, but I had talked about that before. Shelby County is doing an excellent job, from what I understand, in disposing of maybe 60 to 70% of their cases through the information. And I would like to bring that here and implement that as much as possible. And as Mr. Maxwell said, the pretrial diversion program would be a great avenue for them, and the drug court program quite possibly might be another good avenue to help go ahead and move these 1,600 cases, get them down to maybe 100 or 200 cases, you know, that's far more reasonable to deal with, and can also alleviate the backlog at the Alabama Department of Forensic Sciences and the caseload down here, and clear these matters up. And I've got at least one or two that are 2013 and it's 2016. They still hadn't come back.
Can I follow up on that? Also, the grand jury system. I mean, there are hundreds of indictments handed down every time we have a grand jury, and 60 to 70% of those cases are pled out. They're never, you know, and it just seems like a huge waste of time and a lot of backlog on the system. Is there a way that the district attorney's office could kind of circumvent some of that and plead out some of these cases before having to go through the whole process of a grand jury?
Sure. Just like you can plea on an information, and when we say that, I know a lot of the public doesn't understand what an information is, but indictment comes out of a grand jury, and a person who is charged with a crime can make a request through their attorney, or if they're representing themselves, to the district attorney's office to plead prior to indictment. That's what it's called, pleading prior to indictment. And when that happens, what the district attorney does is they type up what's called an information. and it is similar to an indictment, except for the fact that it's not presented to the grand jury, and they don't vote on it, and it's basically the arrest warrant typed in a little bit different form, and it's at the request of the defendant, and the defendant can then go in front of a judge and say, "Judge, to this information, I plead guilty." And if they do that, especially in a lot of these drug cases, then the district attorney's office could shoot a note to the Department of Forensic Sciences, pull that dope. You don't need to test it now. And then that's, less on them as you go also. So it would be a two-pronged benefit.
Is that something that you'd be, if you were elected district attorney, is that something you would be willing to do?
I think that is the most efficient way to do it, and definitely would help law enforcement, Department of Forensic Sciences, the judicial system, top to bottom.
And
Absolutely. I've been preaching this, I guess, for the last few months. I think this is a great avenue. There's going to have some wrinkles that'll have to be ironed out, but by far, I think that would be a great help all the way around for the community and the backlog with the grand jury cases that you were mentioning.
Let me ask one more, Ricky, and then I'm going to give it back to you. And I think we may try to take a break at the bottom of the hour. I know we have the Phyllis Schlafly report coming up, and we'll try to get out of here at 8:30 to take a little break and let y'all get a drink of coffee, and then we'll come back and talk some more. But I did want to ask you, you mentioned law enforcement, and neither one of you mentioned the clerk's office, but I have talked to both the clerk and the sheriff and the police chief about this issue, and that is, what can you as a district attorney do to kind of help lighten the load on the circuit clerk, on law enforcement? They have to have officers who are in there to testify. Sometimes they have to have somebody to cover their shift or cover their patrol or cover this or do that. Is there a way that, and do you have any ideas? And if you don't, that's okay. I know there are provisions probably already in place that I'm not aware of, but I'm just asking, as a public citizen, is there a way to do something that could maybe help save the circuit clerk a little money somewhere, because she's always trying to scratch up pennies to keep everybody in her office working, and to help relieve some of the burden on law enforcement in their capacity as well?
Well, I know one way, just off the top of my head, in regards to law enforcement. I think currently, when a preliminary hearing is scheduled, the directions to the clerk's office is to subpoena for the preliminary hearing everybody who is listed on that arrest warrant. Now, a preliminary hearing is not for the purpose of determining guilt. It's only to determine probable cause. So in reality, you basically just need the case officer or the lead investigator in most of those cases to make out probable cause. In a preliminary hearing, hearsay evidence is admissible in a preliminary hearing. So a officer in a burglary case could come in and testify, say, "I went to John Taylor's house and John Taylor told me that his house had been broken into." That would keep John Taylor from having to come to court and testify to that one little fact: my house was broken into. That's all he can say. I don't know who did it, but my house was broken into. So you could circumvent a lot of witnesses coming to preliminary hearing just by doing that alone. Just subpoena the case officer.
Mr. Jones, you have any ideas?
I think that's a great idea, and most of the preliminary hearings, we all know, are waived. And usually the defense attorney, he wants to talk to the police officer and kind of find out the facts and circumstances, and he can usually make a quick determination on whether or not there was probable cause for the case to go forward. A lot of times there are cases where they are needed, but I would agree, I would say probably 90% of those cases would fall in that category. I'd say there's probably maybe 4 or 5 cases usually actually are heard at most preliminary hearings is probably my experience. So there might be 100 on the docket, but 4 or 5 are actually go forward with the preliminary hearing. So I think that's an excellent idea.
All right, Rickey, we got about 2 minutes.
This will be real quick, and some of the public may not know what I'm talking about. Currently, open file discovery. If I'm going to prosecute you, you can have a copy of anything in my file. Will that be your policy, Pat Jones?
Absolutely, that's the way it is right now. And unless they ask for a preliminary hearing, I think that they kind of use that as a stick in that regard. But absolutely, the open file discovery, and I may look at doing some different things similar to what maybe Kirk Adams is doing or Mr. Armstrong. I think where they maybe even mail the information to the defense attorney, even with a plea offer to negotiate it at the early stages that may facilitate the information. And because we're short on time, I'll let Mr. Maxwell.
Yeah, I've always looked at it that what have we got to hide? So if you have open file, you just put it to them. They're going to learn anyway. I mean, you as an investigator, that you're going to find out everything that we've got anyway. So why not just say, here it is, here's what we've got. And if you have a good case, which most of the time the police department does put together a good case, that helps facilitate an early plea, and which will help prevent prolonging and dragging things out.
All right. Well, we're gonna break away for a message from Phyllis Schlaply, and get those phone calls in if there's something that you'd like to ask. 671-0075. We got the first half hour in the books, and we'll be back for 30 more minutes of questions and answers right here on AM 1450 WDYG. Thank you, Larry. We're back now for another half hour of good first round. I thought you both did very well. Rickey's phone has been blowing up with people sending him questions to ask. So, Rickey, we'll start this segment off with you. If you got a couple of questions, go ahead, and then we'll go to something else. I'm going to make a statement. This is not a despairing of the current administration. So I'm not being critical of the current administration. What I'm asking. But the current administration is very aggressive and wants a maximum for even running a stop sign. A recent case, a victim said when the people pled guilty that they did not like that they were put through all the preliminary hearings, stuff like that. One circuit close by, you can go sit down with the district attorney and say, my client messed up, and you can get a reasonable offer. This circuit, you go, my client messed up, you get the death penalty. Okay, how are you going to be on attorneys coming in and sitting down and being honest and said, my client's a good person, they've made a mistake, and coming up with what is a reasonable offer, not a maximum offer? We'll start with you, Mr. Maxwell.
I don't think you can ever go into negotiations with a defense attorney saying, I want the maximum. That's like going to a car dealer and he's saying, I want sticker price. You're just going to turn around and walk off. And it's not going to work. When I was working in the district attorney's office, and this has been several years ago, Judge Jackson was a judge, and I had a defendant that was charged with raping a young girl. And the facts weren't the best facts in the world, but the defense offered to plead guilty to rape first degree if we would give him 10 years, which was the minimum. And I talked to the young lady and her family, and they were in total agreement. They didn't want the young lady to have to get on the stand and rehash the whole thing, go through everything all over again in public. And make a long story short, I went to my boss and was told, no, if he can't take, I think it was 25, 30 years, we go to trial. So we go to trial, and the jury found the man not guilty. So my first impression is here we had an offer on the table where a man would plead guilty, he would go off, he would have to register as a sex offender, but now he's back out walking the streets because of an arbitrary rule that you're going to have to go for X number of years. It just doesn't work. You've got to look at each case individually. Each case rests on its own facts. You can't have a hard and fast rule for everything. You can't say, I want robbery, 25 years on every robbery first degree. You just can't do that because the facts are different in every case.
Mr. Jones.
I'm going to concur completely because there are as you say, and every pot's got to sit on its bottom. There's some cases that need 99 years or life without, or the death penalty, but there's some of them that surely don't. And if it's a, I don't know if it's I don't know. There's so many different cases that are popping in my mind, whether it's a drug case, or whether it's a speeding ticket, or a lot of times the circumstances they need help with. If it's a drug case or alcohol case, they probably need some rehabilitation. There's some times where they've exhausted those rehabilitation and they've got to go to jail. They've got to go to prison. If that's basically, they've made those choices. They've had the opportunities for second chances, and they've turned their face on them or turned their back on them. But absolutely, I can promise you that we are going to be reasonable. We're going to look at the case as it stands on its own right there and what the facts and circumstances are, and every one of them doesn't need the maximum sentence.
This question excludes Doug Valeska. Okay, so I'm not asking you this. The staff in the district attorney's office, when we had the first question and answer, there was an answer given that gave the appearance to the staff of the DA's office they were going to lose their job. I'm not saying it was from either one of y'all, but of one of the three candidates, that was their perception.
Okay.
Point blank, excluding Valeska, because there's been question and answer whether he would be used to prosecute cases. I'm not asking him. The majority of the staff at the DA's office, do you plan on keeping a lot of the staff?
Absolutely.
Okay.
I think we have a phenomenal staff that's already there. I have. I hope that they'll want to stay, but I think that they have it's a well-oiled machine. I think it's doing an excellent job. Can we make improvements? Absolutely. And I want to get input from them to figure out, because they deal with it day in and day out, even far better than I can understand it. They'll know better ways, just like you know better ways to do your work job, and bringing that in and incorporating that in to make it even get more efficient is something that I would look forward to. And with that, I'll pass to Mr. Maxwell.
I have tried to speak individually with each member of the district attorney's office staff, like I say, excluding Mr. Valeska, and have told them point blank that I would love for them to stay on. I have no intentions whatsoever of terminating anybody. Now, like Pat said, there may be some that say, hey, I don't want to work for Gary Maxwell. But as far as my intentions, I would love to have every one of them stay. And I think that if they get the proper training, if they go to the proper seminars that's put on by the National District Attorneys Association, that staff can be one of the best in the state.
I'd like to just touch on one thing, Mr. Jones. I'll ask you this question simply because I want to know what your take on it is. Y'all were talking about Rickey was asking the question about maximum sentences. I have sat in cases, and I remember one in particular where a defendant who was out on bond. Rickey, from you actually, on 3 different cases at one time, shot and wounded 2 police officers in a convenience store robbery. He was given 600 years, which I know makes a statement, but what good does it really do? What are these huge sentences? We hear people all the time that get 200 years or 3 life sentences or what? Well, you only got 1 life to give. You don't, you know, what, so what is the purpose of all the piling on the years on these defendants once they're found guilty?
Well, I believe that, of course, that's the decision of the judge what he's going to sentence them to. We can ask for recommendations. We can ask for maximum. A life sentence in the state of Alabama does not necessarily mean a life sentence. It depends on the facts and circumstances. You can get out in a lot. You can get a parole in regards to that, and come back out. And basically, if they're running wild, and I guess that's what you're talking about, consecutively, that's going to basically shut down that ability for them to be back out on the streets. And there's some people that don't need to be back out on our streets, particularly if they're shooting people. And in my opinion, if you can't give them life without, then those type sentences may be appropriate in the circumstances.
So this is basically a way, Mr. Maxwell, to keep somebody in jail and not give them the opportunity to ever get out. Is that the way you see it?
In speaking with and having met with members of the Alabama Pardons and Parole Board, any sentence totaling 30 years or more is the same thing. And I think that we've seen that with some of the big sentences that we have seen. The rule of thumb is 13 years is the most that you will serve before you are eligible for parole. So if you've got a 100-year sentence or you've got a 30-year sentence, you're going to actually wind up serving the same amount of time before you're eligible for parole. That doesn't mean they're going to get out on parole, but they would be eligible for parole. Now, one of the things that I have heard from the Board of Pardons and Parole is this. If a judge says, I'm going to give you 99 years, 99 years, 99 years, and 99 years, it shows that Board of Pardons and Parole that judge felt like that this was a very serious offense, and they are probably going to be less likely to give him parole the first time he comes up if he's gotten sentences that are piled on.
Okay.
Death penalty cases, and there's one at Caron Davis, and there's been a lot of talk about Caron, but when you look at the file, part of Caron Davis not going to trial is Caron Davis's fault because he's fired his lawyers. He's been difficult for attorneys to work with that the public don't know. They just hear he's been in jail for 8 years. But a lot of his pain is self-inflicted pain. What are your plans to move some capital murder cases on to trial? I'll start with you, Mr. Jones.
Well, a lot of that is up to the judge and his decision. I would like to get those done as fast as possible, and you're exactly right. I believe he's been through, is it 2 sets of attorneys already?
I think possibly more than that.
He's on his 3rd, I think.
All right. So, and because it's a capital case, you've got to give the defense an opportunity to become familiar with the case so that they could present a defense for him. And of course, we all know that a capital case, if he's found guilty, there's going to be, unfortunately, a lengthy appeal process that's going to go on for years and years. So you want to get it right in the beginning so that you don't have to retry the case again and again, as sometimes happens when you don't have all your I's dotted and your T's crossed. But I would absolutely, I believe with Mr. Maxwell, want to get that on as fast as possible. A lot of the foundational work has already been done. When they get the file, it'll already be in there for them. They just need to sit down, digest it, read it, meet with their client, and develop whatever their strategy is going to be. But to answer your question more directly, absolutely, we want to get these cases moving and get them off the dockets.
Mr. Mack.
Well, I believe in our debate, somebody asked a similar question, and I responded that I have been involved in over 40 capital murder trials, and Pat said that he had not been involved in any. I can hit the ground running. I know how to try capital murder cases. There's not going to have to be any learning process for me. When Doug Valeska leaves the district attorney's office, there will not be anybody in that district attorney's office that has ever opened their mouth in a capital murder case in a trial. So there's not going to be anybody there with any experience as far as asking questions, doing voir dire, and so forth in a capital murder case. Now, to answer your question, what I would do is, day one, go in and file motions on every one of those cases and ask the judge, Judge, I'm here, I've tried them, I know how to try them, set one a month. Let's get them over with, you know. And I don't see a problem in the world with the judges being able to do that. Of course, you're going to take the oldest ones first because those attorneys have probably been working on it the longest, and put the newest capital murder at the tail end. But set one every month, Judge. I can tee it up. I can try them. I've done it. I know how to do it. No problem with me being able to do that.
That brings up an interesting point to me. Yes, sir. You wanted to say something
Just
else?
one quick thing. I have been involved in a capital murder case. I had to withdraw because I became involved in the chain of custody on some evidence issues. But I want to say this, that I can definitely do a capital murder case. I have the resources, I have the knowledge, and please don't think for an instant that I can't try that case just as Mr. Maxwell can. I know exactly what needs to be done, and it's when you're trying a case, it's kind of like, I don't know, mowing the grass. At first, you learn some new things about your yard, but after you've been doing it for 10 years or more, you know how to mow your yard or make up your bed, you know, and it is an easily acquired skill, and I'm just saying that I have the skills. Please don't think for a moment that I don't. I know Kirk Adams, when he took the district attorney's office in Dale County, he had never tried a capital murder case. I know that he's an excellent a district attorney, and I have only high esteem for him and his staff. Also, I believe Jeff Sessions and Luther Strange, before they became attorney generals, had never done a capital murder case. So don't think that I will not be fully capable of handling that aspect of it.
Okay. I want to touch on this while we're on this subject, because you talked about your experience, and obviously you have it, Mr. Maxwell, and I do appreciate that and understand that. What I want to know, and the question that I've been asked, that I said I would ask the two of you, this is more or less a changing of the guard. Doug Valeska has been the district attorney for years and years and years. How do you see yourself as district attorney? Is this a one-shot deal for you? Is this something that you're gonna try it, and 4 years from now, if it's not working out like you want it to, you're just gonna say bye? Or is this a commitment that you're making to be the district attorney of Houston and Henry County for as long as you remain effective in the job, Mr. Maxwell?
Well, you know, early on when I was thinking about this, I was thinking about it as a one-term deal and trying to build the district attorney's office back up to be more efficient. And back right at the time of the primary election, my wife had a very serious problem that we went to the emergency room and they thought she was having a heart attack, and my first inclination was, oh my gosh, I'm doing this to her. that I'm causing her to have a heart attack. And thank goodness that was not the situation, that it turned out to be something else after they did a heart catheterization on her. But after that, I come to the realization, I said, you know, if I'm going to put my family through this, and if I'm going to go do all the things necessary to become elected, then I think that what I ought to do is I ought to let the citizens of the 20th Judicial Circuit determine when I should quit. So it's a change from what I said from the beginning, but I think that those citizens can tell me, Gary, it's time for you to go, or Gary, we would like for you to stay. And that's what I intend to do. I think that I will, if I am elected at the end of the term, I will put my name in the hat to go again. And if the good citizens of Houston and Henry County say we want to keep you there, then that's fine, and I will do it, and I will be committed to doing it as long as they want me to be there.
Mr. Jones?
And from day one, I've always been committed for long term. I'd like to serve 3 terms. And if my body will hold up longer than that. But I want to be district attorney 24 hours a day, 365 days a year, constantly. I want to help in any and every way that I possibly can. That's just who I am. If you'll catch me at the office, I'll be down there sometimes, 9, 10 o'clock at night working. I know that may be strange, but even when I previously worked there, I'd be working on weekends, getting ready for trials. I'd be down there till 10 or 12 o'clock at night when I was in the DA's office when y'all had me in Abbeville up there. And I enjoy that. I'm passionate about it. I like helping in any way I can, and I thank you for that question.
I know Rickey's got a couple more I want to get,
Yes,
so let's try to get these some real quick answers on some things.
Yes.
Through my investigation, I have learned that there's a large portion of the public out there, Democrats especially, who were not allowed to vote for any of y'all in the primary election because they voted on the Democrat ticket. However, in the runoff election, those same people will be able to vote for either one of you. How do you feel about that, and what would you say to prospective voters coming up in the runoff election, Mr. Maxwell?
Well, on March the 1st, I had, I say some phone calls from folks who called me and they said, they wouldn't let me vote for you. And I said, what do you mean they wouldn't let you vote for me? And just that, they wouldn't let me vote for you. And I said, well, when you went in, did they ask you Republican or Democrat? Yes, they did. What did you tell them, Democrat? I said, that's the problem. I said, we were on the Republican ticket, and if you went in and told them that you were voting Democratic, our name is not on that ballot. And I tried to explain to them, I said, when the runoff comes, you won't be asked that question because there will only be 2 people on there, to be Mr. Jones and myself. So when you go in there, don't give up. Don't say, well, I can't go vote for Gary Maxwell or I can't go vote for Pat Jones. You can, even though you voted Democratic the first time, you can go and vote. And my thing is this. This is a critical job that everybody ought to have a say-so in. And now that it's down to 2 Republican candidates, just because you're a Democrat or been a lifelong Democrat, don't think my say doesn't count, and it certainly does.
Mr. Jones, you got a comment real quick?
Real quick, absolutely. We're glad that you have that opportunity now. And again, I have the same questions come to our telephones and things like that on that same day. And please know that you can vote. We need you to vote. Your vote counts and is important.
Rickey, I'll give you one more, and then I got one more, and then that's going to have to wind it up. I'm afraid we're getting close to the end.
Right. As DA, you are very concerned about victims, and I think that's been made clear in the primary race victims are on your mind, and victims are very
Absolutely.
important in your job as district attorney. But with a swipe of a pen, a police officer or a person or the DA can change and alter a person's life forever. Are you going to bring a lot of common sense into your position as DA, or are you just going to look at it as a textbook case? Are you going to look at each case individually and have in mind the circumstances of the offense, a lot of times not necessarily the offense? Because there's been some cases that they've been charged because the prosecutor didn't like the sheriff. So he changed the charges of what the sheriff was charging the person. Are you going to look at the circumstances and how it affects to solve the problem, or just throw the book at everybody?
I'm going to try to use common sense and wisdom to try to pray about every case, and I think that's critical and critically important is in the application of common sense and wisdom into the law and the facts and the circumstances of every case.
Mr. Maxwell?
I think you got to rely heavily on the law enforcement. Those law enforcement officers go out there, they risk their lives on a day-to-day basis to catch the bad guys. And in doing so, you know, you've got to look at what they have investigated, what facts they have determined, and the charge, like you say, that they have arrested them for. And there's going to be times when you go into a situation and you may want to bump up a charge. You may have a situation where a person has been injured and the injury is more serious than they thought about being. But you got to use the common sense. You got to weed it out and get it down to the level. There's too much overcharging being done.
If we were adversaries in the courtroom, I would have objected and said, asked and answered. We covered that. Anyway, last
I wish
question.
we had another hour, because I got
do
more
too.
questions.
Well, this will be our last one, and it's really not fair to hold this one to the end, but I did it anyway because, you know, I've never been accused of being fair. Y'all have been asked several times by several different people about Country Crossing, about the gaming operation down there, the gambling going on down there, the bingo going down, whatever you want to call it. And I remember asking and having heard others ask you about the DA's office investigative powers and investigating down there to see if what they're doing is legal and making sure it stays legal. And I got a couple of different answers at a couple of different times. So I want to clear it up once and for all. If you're elected DA, will you investigate what's going on down there? Will you make sure that they have bingo stamps on those machines they're using for whatever they're using them for down there? And let the public know what's really going on down there, and is it legal, and make sure and give us assurances that what they're doing is within the law. Mr. Jones.
Well, I think in my previous responses in regards to that, it's always, if I personally do it, I become a witness, okay? I believe it's the sheriff's responsibility to investigate the activity that's going on down there. And if there's anything legal or illegal being done, and he finds that if there's something illegal being done, he finds that it's meritorious, then he would bring forward charges that would be presented to the grand jury. The grand jury would determine whether to indict or not to indict. Does that help clear it up?
That's for me, Mr. Maxwell.
Well, under the statute that Houston County operates under, they have to have a permit to do it. And the very first wording or first sentence under that says, no qualified organization or club shall be permitted to operate a bingo game unless the sheriff of the county first issues a permit to the organization or club authorizing it to do so. So,
but that was amended by Mark Culver and the Houston County Commission that allowed them to give a permit as well.
And the governor now is putting that duty back on to the sheriff and or the district attorney.
Exactly.
So I know from talking to Donald Valenza that he has sent his people back down there, as they're doing right now, to determine and look and see whether or not it's legal. And talking from Donald Valenza, it's his opinion that what they're doing right now is legal.
Okay.
So I have full faith in Donald Valenza and his investigation. If for some reason Donald was to tell me, he said, Gary, I don't think that I can be objective in this, then get somebody else. But yes, you're going to have to keep check on it, and you have to look at it and see periodically, are they doing things legally?
But the short answer is that y'all would not use your office to investigate down there. You would depend on the sheriff.
Well, when I say use my office, there is no investigator in the district attorney's office right now.
Okay, that's what I wanted to get to.
So I would like to hire a good qualified investigator, but until that time comes, I would have to say whoever.
The law says that you request the sheriff to do the investigation.
Exactly.
Okay.
So there's a law, but I do want to say this. Although the Attorney General has some powers to come in and do things on a grand jury, you're elected as our representative. He is not, and they have yet to put anybody in jail on these bingo stuff. So do y'all have the stamina to tell the Attorney General, if you're not going to put somebody in jail, get your butt back to Montgomery?
First of all, I wouldn't invite the Attorney Generals up to come down and convene a grand jury. I mean, I just don't think. I mean, I'm sure he could probably get that power. He could probably get an order, but it would be over my objection.
Thank you.
And I think the Attorney General does what he wants to do. That's obviously what's transpired in the past. And I don't know that our local district attorney's office can mandate to the Attorney General what he can and cannot do. I've seen cases over in Coffee County where the DA said, this is not a good case, I'm not taking this case, and he took the case anyway. We won the case, but that's just, he does what he wants to do for whatever reason.
Would you put your foot down with him when you felt he was wrong?
Absolutely.
Thank you.
Okay, we're going to have to let that be it, gentlemen. Thank you so much for being here. Matt, Larry, thank y'all for running things for us and keeping it all set up. We got to get out of here before we mess up the log. We'll see y'all later. Bye-bye.
Thank you.
Thank you, John. Thank you, Ricky.
Thank you, guys.
Thank you.
Thank you, my friend.
Yes, sir.